This is Lysha Holmes, and I'm your host on the Recruiters Recruitment podcast. And I always think when there's a laugh starting a show, you know you're in for a treat. I have got to know this particular individual through a real life and virtual community that I have very proudly co-founded, the Women in Recruitment Leadership, which if you follow me on LinkedIn, you'll know more about that. And we've met quite a few times. We've actually used this particular individual's beautiful offices in Manchester, and I've got to know her in other events as well. We've both sat opposite each other and had plenty of conversations around her expert topic, which I think if you've clicked on this link, it's something that you probably either know you need to know more about, or it's something that's possibly very relevant to you right now. Or maybe it's just because you're just genuinely interested in upskilling yourself in all things legal. So without further ado, please welcome today Hannah Morrison, who is an employment lawyer at Brabners. Welcome to you today, Hannah. How are you?
Thanks, Lysha. I'm really well. I'm really excited to be here. Thanks for having me.
I am very excited for you to be here too, especially. I mean, I don't know whether you're going to break out in song because if you're watching on YouTube, you'll see she's got a very nice guitar sat behind her. Maybe
I
that's what
can't I,
play.
I can't take the credit for that one. It's my other halves. I play the flute, which is a lot less rock and roll.
Oh no, but that would be beautiful. I didn't know that. Maybe that's something we should end the episode with. I feel like that would just be so flamboyant,
Oh,
wouldn't it? Especially with an amazing topic we're going to talk about today. So I know who you are and what you do because you are an absolutely imperative part of the leadership community that I'm very proud to be part of. But can you just give us an oversight as to what Brabners do and what your actual role is, what you specialise in?
of course. So I am an employment lawyer by training, but I have found myself over the years having a particular specialism advising all kinds of businesses in the recruitment sector and all the way through the supply chain. So I have clients who are umbrella companies, um, recruitment agencies supplying temporary workers, contractors, permanent placements, executive search, up to managed service providers. Um, and all of the sort of particular regulatory nuances in the UK and employment law nuances that come with hiring and supplying kind of atypical workers, agency workers, contractors, etc. And I have been at Brabners my entire legal career, which is coming up to 11 years in September. Um,
Congratulations.
so we're Thank you very much. I am based in Manchester, but we have offices all over sort of the north of England, but clients all over the UK and some overseas as well. Brabners is a full service law firm, so we basically help clients with pretty much all of their legal needs throughout the life cycle of setting up and running and exiting a business, and also personal needs like matrimonial support, wills and estate planning, that sort of thing.
Amazing.
So yeah, and it's really exciting because particularly in the area of law I do in employment, you often get to help clients kind of, as I say, all the way through the life cycle. So, as a law firm, we help clients with founding a business, incorporating a company, drawing up shareholders agreements in terms of business, through to supporting them hiring their first employees, sometimes firing their
Oh,
employees,
yeah.
um, dealing with backdoor hires, disputes, all the kind of day-to-day issues that come up when you're running a business, through to much nicer things like exit events and helping businesses kind of realize the value that they've built, whether that's, an arm's length sale, whether it's private equity investment, management buyout. We have lots of recruitment clients looking at sort of alternative ways to realize the value in their business through, for example, things like employee ownership
I was
trusts,
just
that kind
about to
of
say
John Lewis
employee.
model.
Ah, that's definitely becoming a big thing
Yeah,
now, isn't it? Mm.
it really is. And I think, particularly for recruitment businesses where so much of the value of the company is attributable to the people, and those people might be a flight risk if you have a kind of traditional arm's length sale to a third party. Actually, when you've got a kind of strong management team, selling to them effectively, selling to your employees and making your business employee owned can actually really recruitment agencies have sort of realized that's the way to help them realize the full value in their business. So yeah, that's certainly becoming very popular. So it's nice, to be involved in the full life cycle and not always just be there when things go wrong, because to be honest, that's often when the lawyer gets a call. If things are going swimmingly, we don't hear from our clients, we assume everything's good. If you get a call, usually it's because there's a bit of a problem. So problem
But
solvers, I
I was
think
going to say
we like to
problem
call ourselves.
solvers, but also foundation builders, because I think that there's so much we can cover, and we talked about this offline, that how on earth can we cover and do justice to your topic? We can't. So we have deliberately cherry picked just a couple of items from that itinerary, which might mean that there'll be a return for you if that's okay, in the future, because I think when we were discussing and agreeing this, that, all those things that you talked about, actually, I could talk about for at least an hour. I could talk about for an hour at least on,
Yeah.
disciplinary action, or, how to incorporate that employee ownership scheme, who should be thinking about it, how does it benefit? These are all things that I'm really passionate about. But actually, I think that we're at a real sweet spot in the economy right now. And actually, it's gone in a cycle, as it always does, because the same thing happened in COVID. When there's a more challenging and tumultuous market, you tend to find there's a lot more people thinking about going for it on their own. And you've clicked on
Hmm.
this link now, wherever that listener might be, and I don't want to mistakenly assume that's why you've clicked on this link, but you've clicked on this because we've named it something to do with launching on your own. What do you need to think about? And I think that I love to think that this is an aspirational landing page for people to say, right, I'm thinking of setting up on my own. I've got limited funds. I've created a runway of, I don't know, 3 6 months of, savings, or maybe they've taken some investment from a parent or whatever. What do I need to do to ensure that I have got the right terms of business, that I've set myself up to not be in a position where I'm going to get sued, or I'm going to find myself in a liability situation? But I'm on a limited budget, Hannah. So what if I'm thinking that now, I'm employed right now, but I know I'm going to go for it. What are the sort of key
Yeah.
things that I should be thinking about and investing in from a legal perspective?
Sure. So I think there are key things to be thinking about, and then there's the question about how you maybe do that on a limited budget.
Okay.
Um, and as I said before, um, quite often clients only come to us once things have gone wrong.
Mm,
Um, because they made a placement and the client isn't paying their invoice, because they've got a dispute with an employee, because they've got a dispute with the service provider, because they've got a dispute with the business partner. And the very first thing that as a lawyer we say is, can we have a look at the contract? Whether that's the terms of business with the client, whether it's a shareholders agreement with your business partner, whether it's the employee's employment contract, because that document sets out each party's obligations and expectations.
yep.
And if you have a falling out, that is the key document in helping to try and kind of work through that. Or if a client says to me, so have I got a good case? I'd say, well, I need to look at what your contract says. Um, and I think particularly when you're starting out, and particularly when funds are tight, and look, let's be honest, there are sexier things to spend that money on: a tech stack, marketing support, a consultant. You don't want to be spending it on a lawyer, but whichever way you sort of create this documentation, whether it's with the help of a lawyer, whether it's with ChatGPT,
Mm,
the things that need to be on your radar. And I think the thing is, with a contract or terms of business, um, the hope is you have something drafted nice and tight and robust, and you put it in a drawer and you never need to get it out again.
right.
But the point is that if anything ever goes wrong down the line,
You've
that
got
is the
it.
document that you need to have created at the start,
Mm,
because that's what you're going to be relying on. So, quite often we see consultants, let's say two of them, going off to set up on their own. They've got a shared vision of where they want the business to go. They do it on handshake, don't need to worry about putting things in writing. We're not getting married, we're just starting a business, we're on the same page.
yeah.
Fast forward 5 years, maybe their view about where the business is going is diverging. Maybe they've had a fallout. Maybe they're at a stalemate or about something. And if you're sort of
Yeah.
50-50 shareholders, then what do we do? And that's where, as lawyers, we'd want to be able to say, have you got a shareholders agreement that sets this out? Or if you want to buy out your business partner because it's all going to be pear-shaped,
Yeah.
what's the mechanism for doing that? How quickly can you do it? And that's where you want to have things like a shareholders agreement if you're going in business with someone else. If you get to the stage of being able to employ staff, an employment contract that
Yeah.
sets out your expectations of them, and to be fair, what they can expect from
Back
you.
from
What does
you.
your commission structure look
Yeah.
like? Is it contractual? Is it not?
Yeah.
Um, policies around performance management, etc., so that they know what your expectations are and it's sort of fair both ways. So I think, there is a perception, and it's totally understandable, as you say, when you're sort of starting out, you've got limited funds, that, oh, we don't really have to worry about that kind of stuff. It's probably not going to be an issue, or we'll spend money on documents and we might never need to use them again. But in life, sometimes things go wrong, and those
Absolutely.
documents that you might have prepared right at the outset are going to be absolutely key.
Yeah.
So, and just kind of like by way of an example, we had a client or prospective client call us this morning to say, and it's your classic backdoor hire situation.
Oh,
Sent a
right.
CV forward to a client. Client says, yeah, candidate looks great, but they're probably a bit too senior for what we want. This gets fed back to the candidate, all goes a bit quiet, and then 6 months later, lo and behold, candidate has turned up at the client, and the recruitment agency is ringing us saying, "Hang on a minute,
Yeah.
I introduced them.
Yeah.
Where do I stand in terms of charging an introduction fee?" And we say, "Can we see your terms of business?" And they say, "Didn't send any,"
Didn't send any.
and
Never mind, didn't get signed
didn't
terms. They
send
didn't
any,
send any.
didn't send
Crikey.
any.
Oh
Um,
no.
and there's really not an awful lot we can do in that situation. And
No.
as you say, even if you've sort of got yourself a decent set of terms of business, if you don't then have the processes in place to make sure they're being sent out, being drawn to
Yeah.
clients' attention or getting signed or whatever,
Yeah.
there's a whole kind of piece around that and processes that you need to have in place to make sure that your business is robust and you're going to get paid for the work that you're doing.
Yeah, exactly.
So I think they're all sort of things that you need to think about. And in terms about how you manage that on a budget, I mean, if you are in a position to be able to join any of the trade bodies in the UK, for example, APSCO, REC, Team,
Mhm.
that might not necessarily be possible when you're just starting out. But all those trade bodies have a really great suite of
Yeah.
template contracts and policies and things that
Yeah.
you can access for free.
Yeah.
Um, Listening to podcasts like this, I mean, we do loads of sort of training sessions and
Yeah.
webinars, trying
Yeah.
to absorb that knowledge from where you can. There is quite a lot out there, and
There
you
is.
know, reputable law firms, accountancy practices that put out blogs and on talk on LinkedIn. And there is our good old friend ChatGPT.
Mm.
It's like the nemesis of the lawyer.
I know.
But I'll be honest, it absolutely has its
Useful.
uses, and particularly for things like policies.
Yeah.
Um, ChatGPT is really good for stuff like that. And you can also potentially use it to prepare contracts. Obviously, the more kind of sophisticated contract you want, the more detailed it needs to be. The trickier it might become. But I'm not one of those lawyers that just says ChatGPT is the devil. I think it's definitely got its place.
Of course it does. It's exactly the same if you ask me about ChatGPT. I think it can be very homogenized. I think it depends on how much you want, what you need. But I think everything that you've said there is really pragmatic. And I think I've always believed that even if you are planning to launch a business on a shoestring, which that was me 20 years ago, quite literally 20 years ago, because Key's 20 this year, there are some things that you should be investing in, and there are other things that probably aren't as important. The swanky tech
Hmm.
stack. How much of it do you actually need? How much, do you
Yeah.
actually need to get those shiny new business cards? How much do you really need to spend on, the nice shared offices? Actually, the things that underpinning foundations of launching a business, I think it's having an amazing accountant, and there are some brilliant people out there who tend to be freelance. I've got two, believe it or not. There's only four of us in the business. I've got two who I trust implicitly, because for me, yes, I could use any one of the different tech stacks out there for finance and running Sage and all those things. I could use ChatGPT to ask it questions, but who do I trust? I trust Helen and Joy, because they know my business, they know me, and it'll take them 2 seconds to reply. Having a good law firm, having a robust set of terms, and it should be that they are not a client unless they've signed your terms, because then it's done. That's it. It's done. It's
Yeah.
in DocuSign. DocuSign's so cheap, or there's other apps available. Whatever it is for monthly subscription, if you don't want to pay upfront for a year, they're honestly, and I think actually you can use it for free if you only send out 5 terms a month or something like. I can't remember what it is now. And then it's, for me, actually just as important is having a very robust marketing strategy. And again, there are people out there that will do it freelance. There's people that share out free content all the time. But I think there are certain things that are the non-negotiables when you're launching a business. And if you are thinking about this as a recruiter, you're unless you have trained as a lawyer or you've done a finance or accountancy degree, that's not your
Mm,
expertise. And that's where I think,
absolutely.
it's really important to get those principles in place. So I think having good terms of business, if you are going to do it in as a shareholder agreement with a business partner, please, it's actually easier to get divorced than it is to get rid of a business partner, right? I think. And I've been divorced twice, I'd just like to say. So I'm speaking as an
Well,
expert.
yes, I'm going to take your word
I've,
for it.
I've done it
Yeah.
twice. And the second divorce, he was also a business partner and I had to buy him out my own business. And he was like, so yeah, gets very messy, guys. Have a shareholder. And that was with a shareholder agreement, let me tell you. So don't assume. I actually think that point was really important because no one sets out anything to fail. No one sets out anything for it
Right.
not to go well. But the reality is that's not how it will be if you're running a business. Even if it's going to
Yeah.
be a partnership and that's it, you're never planning to grow or scale. So I think it's really important advice. Can we just cover off, please, restrictive covenants? As we
Oh,
record this in
yes.
2025, where are we right now in terms of your advice? If I always say if it's fair, if it's 6 months, can they hold me over my restrictive covenant?
Mm. I mean, the headline is, yes, you can be held to your restrictive covenants. And I think there are, you know, people out there who think, who have the perception that actually restrictive covenants are never really enforceable. I'm just going to take a punt. And look, the reality is that as a business, trying to enforce someone's restrictive covenants, if they're breaching them, um, can be a very costly exercise. But if you're successful, you can actually claim your costs back. And sometimes it's prohibitive. Um, but yeah, the sort of fundamental legal point about restrictive covenants is they have to be reasonable and they have to go no further than what you really need to try and protect your legitimate business interests. So, trying to prevent someone from working, from competing, working in the sector that they've trained in and that they're experienced in for 3 years, that's never going to wash. It's unreasonable and it's usually unnecessary. Um, so I think there's two things that you touched on there. First is the duration of them. And there's a sort of there's no kind of clear guidance on this, but there is a general understanding that 12 months is pretty much the maximum that a court will enforce, but it depends on the seniority of the individual and it depends on the kind of business that you're in. So, for
Okay.
example, if you were an insurance company and your staff are only contacting clients once a year when their insurance policy is coming up for renewal, you're more likely to be able to justify holding them to 12 or even 13, 14-month restrictions because once they leave, you're going to want to capture that full cycle of them sort of getting back in touch with
Yeah.
clients and trying to solicit their business. And the other way you've got to think about it is if they leave and I've got to bring someone in, how long is it going to take that replacement to establish those
Yeah.
relationships and kind of
Yeah.
shore up those relationships? And that's one of the really important factors you've got to think about when you're looking at the length of the restrictions. And the other one is, the seniority of the individual and their hold over clients and candidates. How much access have they got to confidential information? Are they in a sort of client candidate facing role? Have they got a lot of experience? Have they got a big personality? Are they a serious risk if they leave that they're going to take out half our client base with us? Compared to, for example, an apprentice consultant who, at least at that stage in their career, doesn't have that same influence. So it would be more unreasonable to try and hold
Right.
them to 12-month covenants,
Yeah.
say.
Yeah.
So one of the key pieces of advice we give is if you've got employees and you give them an employment contract with restrictive covenants in it, you need to remember to keep it under review. And as that employee grows in the business, they get promoted, they've been there longer, they've got more sway. You need to be looking back and saying, actually, when they first started, I only gave them a 3-month non-compete clause or a 6-month non-solicitation of clients clause. But they're now my top biller and a senior consultant. I've just promoted them and I'm paying them a fair whack. Actually, I think at this point it's appropriate to update their employment contract, not just to reflect their job title and their new salary, but to change their restrictions or to extend their restrictions. And that's something that I think quite often gets forgotten about. And then you end up in this situation, worst case scenario, where you've got like the MD of a company that's worked their way all the way up from being the receptionist or something, and they've got no restrictions or 6 months restrictions or something, and it's just not fit for purpose. So, yeah, key
Do you want to
piece of
know
advice there is
the
whenever you're
start? Yeah, the start
go on.
reality. Oh, sorry, I think the signal just cut out there, Hannah. I didn't mean to talk across you.
I don't
The
know.
start reality
That's all right.
is I'm a rec to rec by day. I recruitment for recruitment companies, and I would say, bit of a straw poll, 70% of candidates that come to me who are always very experienced senior fee earners have not had their contracts of employment updated since they first started in their job. So I've got people
Yeah,
who are on, they're associate directors, they're on 60, 65 grand, whatever the basic. They have been
yeah,
in a company 4, 5, 6 years. They're billing, 500,000 quid a year, whatever it might be. And they've still got contracts of employment that says recruiter, 30K, 6 months recruit, whatever it might be. And it is
yeah.
more common than not. So actually, although this podcast is aimed at those who are thinking of setting up for existing founders and leaders, when was the last time you actually updated your employment contracts? How regularly would you recommend it? And does it need to be prescriptive when each person gets a promotion, for example? Should they then get a new employment contract?
So on that second question, yes, every time, well, at least every time someone gets a promotion, that should be the thing to jog your memory to say, let's have a look
Right.
at their contract, because at least
Okay.
you should change their job title and their salary. Now, sometimes you can just do that through a letter. You don't have to completely
Right.
reissue the whole employment contract.
Sure.
But if you're in a business like recruitment, where, because not every single employee in every single sector has restricted covenants in the
No.
contract, but look, this is a people relationship based sector. So that should be the sort of prompt for you to say, right, they've been promoted. Let me look back at their restrictions. Are they appropriate, or actually should they be extended commensurate with
Mm.
their new job? In terms of reviewing the employment contract generally, if you have the luxury of getting someone to look over it once a year, great. But it's not always that necessary. It's usually just if there've been sort of significant changes to employment law.
Mm. That's really useful. And I think I always say if we can get one listener to create one action point, that's my job done. And I'm telling you now, every leader listening is going to go, oh shit, we've just done a load of appraisals. We're in a new financial year. Did you do this? Because I'm telling you
Yeah,
now, more than half will be going, no, they didn't. So
yeah,
I think that we weren't planning to necessarily speak about that, but I think that's actually been really insightful. And I would say more often than not, because of how I work and it's covert candidates, and I'm not revealing my secrets here. The advice I always give on restrictive covenants is if it's an up-to-date contract with your existing job title and it's, commensurate to what you're currently doing and it's fair, I always tell them to go and get external. I always say go and get external legal advice. I am not a lawyer, that's my caveat. But is it enforceable if it's 12 months and it's to, not be able to contact anybody in the recruitment space, full stop, then it's not enforceable. But if
no,
it's, and
no,
if these are clients that, you are currently working with and you're going to a competitor where they also work in that space, again, it's more likely that you're going to have a company that's going to go, well, there's not much I can do about that. It's the candidates they want to protect.
exactly.
So it's the wording of it, isn't it? Because if
It,
you're in a candidate short market, actually, the candidate aspect is probably more important than the clients in the restrictive covenants.
exactly. And sometimes I think candidates get forgotten about actually. But yeah, depending on, yeah, if it's candidate short market or a very, very niche sector that you're in, as you say, the candidates can be just as valuable.
Mm.
So yeah, it's about, as you say, it being reasonable and about it being tailored. The whole point or the whole reason why, well, one of the reasons why restrictive covenants are sometimes not upheld by a court is because they're just a pure restraint of trade. You're just trying to stop people competing. Well, look, we live in a capitalist society here.
Yeah.
Competition is promoted. So you can't just stop someone competing full stop. But what you can stop them doing is exploiting, the information they've gained and the relationships they've developed through working for you. So yes, you can't say you can't contact a single client of ours for the next 12 months.
Mm.
What you might be able to say is you can't contact any clients that you dealt with
Yep.
while you were employed by us for the next 12 months.
Yeah. Or placed
So
with.
it's really all about tailoring it.
Mm. And please don't send your existing database information from your work email to your personal email because, oh, Hannah, this happens. I mean, my clients tell me stuff like this, and I'd just like to say, huge caveat with this one is this is not about my candidates doing this. This is the testimony of what other people have done, and you just think it's just very naive. I mean, I can actually probably count on one hand in 20 years of business how many times a candidate has actually had it enforced upon them because they've broken a restriction. I'm a huge believer that restrictive covenants, when they are fair and justified, ethically, you must honour them. And I think there is truly enough business out there. And, I think very often it is down to the candidate relationship. But if you're, dealing with a future employer, or you're looking at setting up on your own and doing things properly, I do believe in creating a moral approach to how you generate business, and you should always
Yep.
honour those. If they're fair, I think you should. That's always my professional and personal advice, is to honour them. And you set your business up to fail if you going in and going after and breaking those restrictions and thinking that they won't find out, because all you'll have then is
Yep.
presumably a legal letter that you're in breach. And we're talking a significant
Yeah,
amount of money, aren't we, if you have to fight it?
we are. Yeah,
Mm.
we are talking a significant amount of money, yeah. And yeah, one of the things you just touched on there is it's not actually just the restrictive covenants you need to think about, but also any clauses in your contract around confidential information. So that'll cover, your CRM, candidate connections, etc. And there will almost certainly be a clause in there, prohibiting you from, yeah, taking the contents of the CRM system with you. And you use the term naive there. Even just in the last few weeks, I've had cases where, and with IT being so sophisticated these days, the company can see if you've opened a file on the computer. It can see that you've suddenly, looked at the pipeline document that you haven't looked at for the last 5 months, 2 days before you hand in your resignation, and it all starts to add up. So
Yeah.
yeah, just be mindful of that one.
I think definitely be mindful of it. And I think, on one final point on this, and then I can't believe we've actually reached the end of the podcast. Where has that gone? We definitely, we haven't even covered overseas stuff, Hannah. That'll have to be a separate podcast, I think. Is the non-solicitation of employees as well. And I think it's something that I'm always really mindful of when people do go and launch on their own. And that they're going to probably go in after, the top biller that's sat next or whatever. But just, these things again, that's why you as a founder and if you're starting out to potentially scout, have these things in place to protect.
Absolutely.
But I think that's where, I definitely want to talk to you on another podcast about the employee ownership scheme, because I think, as crazy as it sounds, as much as it contradicts the whole notion of why I'm in business, which is to, take people or place people out of businesses where they're not happy, not being looked after. Actually, what I want to do is partner companies that are looking after their team members and are doing the right thing. And I think it's, that you called it the John Lewis model. I mean, it's becoming much more prevalent now. And it just prevents the risk of, your team being targeted because they've got an
Yeah,
invested interest in the business, haven't they? I think it's definitely
absolutely.
the way forward, and it's the least risky way to I guess give a golden handshake. But it's also, from you listening, if you are being offered this, it's the safest way for you to become an owner in something without having to
Absolutely.
take all the risk. Will you come
Yeah,
back?
and it of course, I'd
Sorry.
love to.
I
Yeah, I
think our
can't believe it's
signal
gone so
I
quickly.
think we keep glitching, and then it sounds like I'm talking over Hannah, and I don't mean to, you guys. It just every now and again she kind of glitches. No, you have been amazing, and I think we could have a whole series with Hannah from Brabners. But in all seriousness, I think I really wanted to hone in on one particular topic. Try not to digress too much, because I think it's such a big topic and it's so important. And if anybody wants any more information or wants to get some expert advice from you, please contact Hannah. Please mention the Recruiters Recruitment Podcast and myself, because Hannah will look after you. And if there's any other, I mean, obviously you mentioned all the other elements of what Brabners can cover. If you need any other sort of legal advice, then obviously Hannah will refer you to one of her other expert colleagues who I've had the pleasure to sit across at. I think it was at Power Hive, wasn't it? Earlier on in the year.
It was indeed. Yeah.
Yeah, it was where I was a speaker at that event. That was good fun, wasn't it? Hannah, thank you so much. And I'm going to hold you to it in season 6, which will be coming later on in 2025. I need you back on, and we'll talk about maybe where we're up to with the employment rights bill, see where that's up to, see if it's something we're still talking about, which I'm sure we will be.
I fear we will be. But season six, wow, that's
No.
so impressive. And I'd absolutely love, yeah, I'd love to join.
Yeah. Yeah, definitely. Well, thank you so much for joining us on the Recruiters Recruitment Podcast.